Peace, peace. Once again, this is part 2 with brother Olakwesu. We got brother Kemo here with us. Gonna ask a couple questions. We're gonna get back into what we were talking about earlier. Going into the attorneys and stuff. So, kind of pick up on that again.
Well, basically where we left off at, this goes for state and federal procedures, that the federal Constitution in America under the 6th and 14th Amendment guarantees the Citizens Counsel. Not only does the 6th Amendment guarantee the right to counsel in criminal matters, but the 6th Amendment also guarantees you the right to effective assistance of counsel. I mean, we're talking about from cases where you might be facing jail time from criminal traffic violations. You can only be appointed counsel in a criminal matter. If a traffic violation rises to a criminal offense, you can apply for counsel. You must also inform your attorney, if you choose to use one, you don't have to ask for discovery. And in Ohio, it's Criminal Rule 16B or 16BP, depends on what the situation is. You can research that yourself. My recommendation has always been to file a motion to suppress. You want to suppress the ticket provided by the officer alleging to be at the scene, because he is only a witness to the alleged infraction. The officer himself is not bringing the charge. He's bringing the charge on behalf of the state in which he and the defendant may reside. And so it's very important to understand the function of your lawyer, a function of lawyering. You may, in most cases, as an alleged African American, have to become your lawyer and try the case yourself. An attorney is a member of the bar. They are an officer of the court. They have a public duty to uphold all court procedures. They cannot misrepresentate you. It'll be a violation back to the 6th Amendment, guaranteed by the 14th Amendment that you will be given adequate, sufficient trial counsel in all stages of the proceeding. Now, we were talking about the case of Larry Ellis Ely having been tried in civil matter CV 90 CV 159, which turned out to be one of the most gruesome police attacks in the United States of America. Anybody who want to challenge the findings in that case is welcome. It's on motion for review to be reopened, where Mr. Ely was attacked by several bloodthirsty Dayton police officers in the Dayton Municipal Courthouse. And according to the records discovered some 20 odd years later, we have established that there were acts of cannibalism by the Dayton police. As I said, anybody can research into the matter, and all claims of assault and the use of deadly force was verified by 5 different jurisdictions. And that matter in itself is one of the mecca cases in America that will be exposed for further review, where it was sabotaged, the evidence was hindered, obstructed from its original course, and the federal law was violated in that case under 18 U.S.C. Section 242. We'll get more into that case as the evidence continues to be reconstructed and put back together in its original form. We want to get back to maybe Mr. Kemo here would like to ask the question. We'll be glad to answer, or try to answer anyway, most of the citizens that are broad questions out here who may be headed to court, not knowing what to do, not knowing what to expect out of your lawyer. And we'll try to help you and guide you through some of the procedural due process issues that may arise under the Constitution 1 through 15. Like I said last week, the last session, African Americans are facing a time of disobedience in law. We've been totally 100% enslaved. We have proof of that, and we have to understand the nature of the beast and why we are privy to these kinds of attacks, even in minor misdemeanor traffic cases. So we have to know the law as it's read. Now, we facing another problem. It's called the Negro Act. We want to talk about that. We want to touch on that today. The Negro Act basically was brought into life, the records say in 1866 it was made law, but the state of Texas had already, under Penal Code 56, ordered that all blacks, Negroes, and any person with 1/8 black blood not be allowed the due process clause as, I'm going to say, wealthy whites, because minorities in all factions were held accountable to the Negro Act and the Black Code. That included poor whites. Now, what we want to talk about briefly...
What about Abraham Lincoln?
Yeah, that's what we want to get to. President Abraham Lincoln, before he became president, in 1855, I believe, had defended a black man charged with being a Negro in the state of Illinois. Lincoln has successfully defended this alleged Negro, claiming that he was a Moor. And Moors, under the 1740 Sundry Act, are not privy to the Negro Act or the Black Codes. It's very important that people of color understand what the Black Code and Negro Act is, and what Lincoln did in 1855 is very important to what we're going through today. Now, the way Lincoln was able to defend this Moor or this alleged Negro is that his accusers, citizens of the state of Illinois, could not establish that he was not a Moor. They could not establish that he was a Negro, where Negroes were banned from each state under certain territory acts. Every state was different concerning the Black Codes of America. And we have proof today that the slavery never ended. It was just amended into Black Codes. And this is why Lincoln paid the price that he did with his life. Martin Luther King paid the same price, as did Malcolm X, JFK, and several other people who stood against the initial acts of slavery. What we have to focus on today is understanding our individual rights that's afforded to us in this country. And when we return, we'll get into federal law, individual rights, and the Everett's Act, passed March 1st, 1890.
All right.
Would like to, did you have a question, sir?
I did have a question. My question is, you're in a traffic proceeding, are you in criminal court or civil court?
Well, we have to focus on the actual charge itself. Was it an infraction, or was the vehicle used in a criminal way, in a way that could have been criminal? Like if you punch somebody, that's a criminal act. If you hit somebody's car or cause an accident, that could be a criminal act. But an infraction, speeding or failure to reinstate,
traffic,
or
like a Parking ticket.
Parking ticket, that's not a criminal act under the term criminal rules. So they cannot be imposed.
Okay. So in the event that it is deemed not to be a criminal act and it's now a civil act, what rights do I have being tried in a civil court?
Well, there are usually more than one charge accompanying the initial charge. So it depends on what you're actually charged with, and then the other charges that follow. So, say for instance, you charged with speeding. What else was it that you was charged with?
2 improper lane changes. 2
improper lane changes and speeding. First, the officer got to establish that you were speeding. If the evidence is not supplied to you in a motion to suppress or discovery, the court must dismiss. Point blank.
All right, right up.
And that answers my question.
All right, so you have to proceed accordingly as the case moves forward.